Hey everyone, welcome back to the VSO Gun Channel. It's great to be here as always. Thank you for tuning in. And I wanted to do a video today on the recent happenings at the Supreme Court. So obviously we saw some really big decisions come across that we've been watching, but then some of the other ones that we were really kind of hoping for, the Supreme Court really didn't do anything of major substance with, and they sent them back down via the GVR method or the grant, vacate, remand, which basically grant certiorari, vacate the previous decision, and send it back down to lower court, usually with some kind of instruction to follow a previous decision that they've made. This doesn't necessarily mean that the lower court's decision can't come back exactly the same. It just means that the new guidance that they've been provided needs to be included. A really good example would be the First Amendment cases that I'm really interested in as it pertains to YouTube. Basically, those cases were sent back down this week, and they were of differing opinion. Should the state be able to do this? Should the state not be able to do this? Does it implicate the First Amendment? And basically what they said in those cases is they need to go back down, and there needs to be a thorough analysis of balancing the First Amendment rights of the people who are posting content and the First Amendment rights of the actual entities that allow for posting of content. So YouTube has First Amendment rights and Facebook has First Amendment rights, and so do American citizens. And you got to kind of put those two together and consider how all of the services available on the internet are affected by the law. So there's a big analysis going on that one. Not necessarily that the decisions were completely off base, but that they need to be thoroughly analyzed to figure out what parts of the law can apply to what parts of the capabilities of those platforms. Same thing with the Second Amendment cases, which is what we like to talk about here. Are those decisions that were sent up to them by the lower courts copacetic with the new decisions that have been made by the Supreme Court? Do they account for the guidance of the Supreme Court in their decision? And even if they want to go the same route, they need to include that in their constitutional analysis. So anyway, what I would like to do real quick is take a break for our sponsor, and then after that, I'll grab a few of these cases and give you kind of what I think is going to happen with those. Today's video is brought to you by Medical Gear Outfitters. They are my go-to stop for anything medical related. It doesn't matter whether you need bumps and bruises kit or whether you need real equipment like chest seals or a cat tourniquet or something like that. They have got a bunch of medical kits over there. Again, they are my go-to shop, and they are great people. I've known Dietrich and the crew over there for going on like 10 years now. So they are definitely a place that you should check out if you're looking to augment your medical equipment needs. And they have a discount code for all of you who are VSO subscribers. You can find that information over on the affiliates page, and special thanks to Medical Gear Outfitters for making today's video possible. So when we're considering the controlling decisions from the Supreme Court as it relates to the Second Amendment cases, the two cases that we're really considering are the Raimondo case, which is the axing of Chevron deference, which is fantastic. And then the Rahimi case, which is a little bit more nuanced. And I think that there's a lot of people I would say that there are more people on the left side of the aisle that are a little bit more disappointed with the Rahimi case than on our side. But what I would say is that it was kind of a mixed bag. So to kind of lay these two out for you, if you're not totally tracking, the Raimondo case said the government, as in the executive agencies of government, can't make the rules up as they go along. They are bound by the terms that the legislature defines for them. And if they want extra powers, they can't just grant it to themselves because they are subject matter experts. They are almost certainly not subject matter experts, as the court said, in many cases. And they may be politically influenced. And because of that, they need to go back through, and if they want new powers, ask Congress for them. In the absence of guidance from Congress, it is the court's decision to determine the input of the executive agency to be valid or not valid in that particular instance. So that basically axed doctrine from 3 decades ago that said that the court actually never intended to be a binding doctrine, that you should give deference to the executive agency because they're the executive agency. The court's like, nah, that doesn't work. The court should make the decision. They can choose to listen to the executive agency or not. When we talk about the Rahimi case, my analysis on that last one was kind of long, so I'll try to distill the Rahimi case down to a couple sentences. You can disarm someone temporarily, keyword temporarily, poses a danger to the public. They specifically cite intoxication and mental health problems. And it expressly says in the decision that while previously in the Heller case, they had considered felonious prohibited status, that may not be something that the court has fully evaluated yet. Consider, for instance, the range case, which is the one that I was really interested in because it has to do with somebody basically defrauding the government for, like $2,500 worth of food stamps or something like that. It's something that clearly a nonviolent crime, didn't hurt anybody. The government is not people. Read that into what you will. Nonviolent, victimless crime. Does this deserve a lifetime prohibition? I think that it's being sent back down to the lower court so that they can definitively say, no, that's not a temporary prohibition, and that is not somebody who is a danger to society. So therefore, working that analysis back into the decision-making process, it very well may end up back at the Supreme Court, but at which point the Supreme Court very well may just say the lower court's decision stands, and then they wouldn't have to grant certiorari for it, and they could just say, yeah, you guys did it right. So letting the lower courts work it out may be the fastest, easiest way to come to a resolution, because after an appeal, the Supreme Court can just say, nah, that was right. Very similar, in, again, my opinion, is the Daniels case, which has to do with cannabis use. So again, temporary prohibition on somebody who is actively intoxicated. Think back to text, history, and tradition. Somebody's walking around drunk after leaving the saloon, and the sheriff says, hey, we're going to take your guns. You can dry out, and you can come get them in the morning. Temporary disarmament. Should drunk people be walking around in the street with guns? Probably not a good idea, right? There's a rational basis there. Does the use of a illicit substance make you lifelong prohibited from owning firearms? That's not what the Rahimi case says. And it does not say that if it's responsible behavior, it can be a cause for disarmament. It expressly says that in the Rahimi case as well. So I think this is going to go back down now. Department of Justice is, of course, going to fight that because they love their power. But this is out of Fifth Circuit, so I strongly believe that the Fifth Circuit's going to be like, nah, that ain't temporary, bro. And we're going to be back here at the Supreme Court yet again, and it's going to draw specifically on the inspirations in the Rahimi case to do that. And when it comes back up to the Supreme Court again, they might be able to say, yeah, that's fine. That was done correctly, as per our most recent rulings. And as a closing note today, there weren't any cases that really dealt with what we care about at this point, dealing with the axing of Chevron deference in the Raimondo case. But one of the decisions that was put down was expansion of the time frame in which someone may sue a federal agency over the evils that they have perpetrated, which I think is fantastic. So anyway, that's what I got for you guys today. I would like to know what you guys think about this in the comment section down below. Are my analyses on point, or do you think that I'm completely off base and that they're going to look at a different part of the decisions as it relates to the cases that I mentioned?